unemployment appeal hearing is kind of like a trial in court, but it's much simpler and much less formal. Appeal hearings can be done via telephone or in person. At the beginning of the hearing, the referee will make sure that everyone is present and then explain the procedures for the hearing. The referee will then review the evidence in the appeals packet and admit that evidence into the official record. If the parties have submitted additional evidence, the referee will sometimes admit that evidence into the record at the beginning of the hearing or wait until later to see if the evidence is needed. Make sure that if you believe your evidence is important, that you do everything you can to get it added to the record, even if the referee doesn't want to, because this hearing is your only chance to add evidence to the record. Next, the referee will likely begin asking questions to witnesses. Typically, if you quit your job, then the referee will start by asking you questions first. On the other hand, if you were terminated, the referee will start by asking the employer's representative questions if the employer has a representative present. Although you definitely need to appear at the hearing, the employer is not required to appear at the hearing unless it wants to. Unfortunately, there's no way to know for sure before the hearing whether the employer will send someone. Either party is also allowed to have an attorney represent them, but an attorney is not required. So let's assume you quit, and so you're the first witness. The referee will ask whatever questions he or she thinks are important. After that, if you have an attorney, your attorney can ask questions to add information he or she thinks is important and to help clarify anything. If you don't have an attorney, the referee will usually ask if you have anything else to add. This is your chance to clarify anything you'd like or to add anything you think is important that the referee didn't ask you about. Take advantage of this opportunity if you have testimony or evidence to add, because this is your only chance to provide it. If you need to appeal again, they won't accept more evidence. Then, after this, the employer or its attorney is allowed to ask you questions as cross-examination. As you give your testimony, you and/or your attorney can also refer to admitted evidence or ask the referee to admit evidence that hasn't yet been admitted. If you have any other witnesses, then the referee would then decide whether to question any of them. After that, the referee will question the employer's representative, and then the representative or their attorney can add or clarify things and present evidence. Then you or your attorney will have the opportunity to cross-examine the employer's representative. After that, the referee will decide whether to question any of the employer's other witnesses if they have any. The final step of the hearing is closing statements. Each side or their attorney is allowed to make a closing statement to summarize why it thinks it should win. I definitely recommend taking advantage of this opportunity. We'll cover more specifics about providing testimony, presenting evidence, doing cross-examination, and giving a closing statement in other lessons.